Greetings, everyone. This is Richard Solomon. Welcome to another week of Taking Care of Business. This week, appeals. What are the nuts and bolts of appeals? And with that, we have our expert, attorney Carol R. Finocchio. And I met her because we were doing litigation and an appeal came up and she was one of the appellate lawyers and she did such a great job. I said, hey, would you like to be on this show? And she graciously agreed. So thank you for being with us and welcome to the show.
Nice to be here, Rich. Thank you so much for inviting me.
All right. So let's talk about appeals. Basically, an appeal is somebody is requesting a review of something that happened in a lower level part of the court system. But I'm sure there's a lot of misconceptions about appeals. So let's just get a little nuts and bolts. What is an appeal and what exactly are you appealing?
Okay, so the first thing that happens, let's give an example. You're in the Supreme Court in a civil matter, and you have a trial, for example, and you win or lose the trial. Now, the person that loses the trial might say, oh, my goodness, I should have won that trial. I want to appeal to the appellate division, which is the intermediate level appellate court. The real issue is, do they have issues for the appeal? Do they have a reversible, harmful, prejudicial error that is likely to get them either a new trial or some form of relief that they're requesting? So that's a good example of what an appeal is. Now, New York State has not only post-trial appeals, they have something called interlocutory appeals, which don't really exist in the federal system. An interlocutory appeal is during the course of an action. Someone moves for summary judgment. Someone has a discovery matter that they don't like the ruling on. In those instances, you can do an interlocutory appeal in New York State, and that's during the course of a litigation.
Okay. What are the common misperceptions that the general public has about appeals and how far you can appeal something?
I think the biggest misperception is that you can appeal anything. You cannot. You could, but obviously it would get dismissed. The real thing that you want to have is you have to use judgment. The first thing is you want to have some semblance of merit to your appeal. You don't want to just appeal anything for the sake of it because that's sort of fruitless. You want to know that you're appealing for a reason. It should be a strategic reason, and you also should have some merit. And then you can assess after you review the papers or the trial and determine what the appealable issues are. You want to make sure you have a judgment or order to appeal from, and you also want to make sure that you know your likelihood of success.
Now, when it comes to facts versus law, let's say someone has decided what the facts are those ever really reviewable?
Yes, they are. In New York State, the appellate division, which is the intermediate appellate court, has the ability to review factual findings, findings of law, and issues involving the exercise of discretion by the lower courts. Now, the Court of Appeals, on the other hand, is a court of law. They can also review issues of discretion in certain circumstances. However, they're not supposed to be a reviewer of facts, except in those instances where the appellate division has reversed something from the lower court by making new factual findings. So there's some limited exceptions there, but for the most part, they're simply a court of law. And that court focuses mostly on policy and legal issues that should be resolved. They're looking for issues of great public importance. They're looking for issues where there's a split of legal authority between the various departments of the appellate division in New York State. There's 4 different judicial departments of the appellate division, and there are instances where the courts in one department will come down differently than the courts in another department, and the Court of Appeals ultimately will resolve those issues.
So let me ask a couple of questions that are related to how the state is split up. So you have 4 departments. So for people who don't know, is the state like northeast, northwest, southeast, southwest, 4 parts?
Essentially, what you have is you have the first department, which is New York County and Bronx County. The second department would be Kings, Queens, Richmond, Westchester, Rockland, Putnam, Orange, Dutchess, Nassau, and Suffolk. The third department is Albany County, Columbia County, Ulster, and there's many more counties. I didn't list them all because we're down here in the second department. At least if you're on Long Island, that's the second department because it's Nassau and Suffolk, and in New York County, it's the first department. The fourth department is upstate New York, and that's Oswego, Monroe, Erie, Niagara, and also many more counties. That's more northwest.
Okay. So for people who are listening, there are 62 counties in New York.
Exactly.
My favorite name is Herkimer because it's such a cool name.
I believe Herkimer is either in the fourth or the third department. I think it's in the fourth department, but I could be wrong on that one.
So there's one court in each of these four places that cover appeals.
Exactly. The first department's in Manhattan, the second department is in Brooklyn, the third department is in Albany, and the fourth department is in Rochester.
Okay. From a physical layout point of view, could you describe for people who may never been to one of these courthouses what they're like?
Well, actually, they're very different. The first and the second department have more history. I believe that they've been there longer. The buildings are beautiful. They are more old world. Although the second department's a little bit more modern. The first department looks very old but restored and beautiful. The third department is more office-like. The fourth department is a newer courthouse also. That's at 50 East Avenue in Rochester. I was just there the other day. And that's a beautiful building, but again, it's more modern and more office-like.
Now, for people who don't know, lawyers are actually admitted to the appellate division when they're sworn in, which is kind of, I don't know if you know why. I have no idea, but I know that when we're all sworn in as attorneys, we are actually sworn in at a different. I was sworn in in the second department in Brooklyn.
That's where I was sworn in also. That's correct. I think it's based on your residence at the time that you're sworn in.
Right, but why are we sworn into an appellate division is only because there's only 4 as opposed to 62 counties?
I'm not so sure. I think that might have to do more with the rules for attorneys than it does with the actual appellate process.
Okay, so let's describe the physical appeal, like let's say in the second department, because
so I'll give you an example.
You go to Brooklyn, right?
Okay, you go to Brooklyn. Shall I give you an example?
Yeah, I'd love an example.
Yeah, okay. Here's an example. When I say my favorite cases, the cases that I work on frequently, I'll give you an example. A construction worker is on a scaffold and he's painting the wall and he falls off the scaffold.
So these are labor law cases. Famous labor law cases.
There's famous labor law cases. There's workplace safety statutes in New York State under the New York State labor law that protect workers so that if they fall off a ladder or scaffold, there's absolute liability on the part of an owner or general contractor so long as the requirements of the statute are met. Then another example is you have an automobile accident. You're driving along the LIE and a car hits you in the rear. And then a third example is medical malpractice. You go to the doctor, he misdiagnoses something, and you lose a limb. So there's 3 good examples. So what will happen is during the course of your litigation, various legal issues will come up. For example, in the labor law case, what happens? The worker falls off the scaffold. The plaintiff's attorney says, gee, here's a worker. He fell off the scaffold. It's a commercial building. There's absolute liability in these circumstances. Let's make a motion for summary judgment so that we get the court to determine as a matter of law that there's liability by the defendants. The defendants oppose it. There's various defenses. One of them might be that the worker's own conduct was the sole proximate cause of the accident. Let's say the lower court grants summary judgment to the plaintiff and says, you plaintiff, you have won on the issue of liability. They issue an order to that effect, and what happens is the defendants say, no, we disagree, we're going to appeal. We think there's factual issues that require a jury trial. So the process actually begins when a notice of appeal is filed. There's time deadlines. You have 30 days from the date of the order with notice of entry to do your notice of appeal. After the notice of appeal is done, if you decide to go forward with the appeal, which often, the lawyers will do when they take the notice of appeal, you try to assess that it has merit. And then there's the whole process of what is called perfecting the appeal. What you do is I hire an appellate printer, and the printer puts together the documents which constitute the record on appeal. You hear the infamous words, quote, on the record when you watch television. What that references to is to all of the things that previously happened. You can't go outside of the record on appeal. You have to use all the documents that were before the lower court. Then once you perfect the appeal, you go to the appellate court to argue it. First, there's briefs. The appellant will file a main brief. After that, the person opposing the appeal is called the respondent. They filed an opposing brief. And then the appellant generally has the opportunity to file a reply brief. After all these briefs are filed, the court will schedule a date for oral argument. Now, in the various departments, there's time constraints. The second department might be a little slower than the first because they go by the actual amount of filings they have, whereas the first department has a term system. The courts with term systems sometimes have a schedule where all of the briefs filed for a certain term will be argued at certain dates in the year. When the appeal comes up for argument, then it's sort of like the debates. If you watch the debates during the political season, the attorneys show up in court. There's a calendar call. When the case gets called on the calendar, the attorneys will stand up and say how much time they want. And then when the case is called, the two attorneys or three attorneys, whatever the case may be, they appear up in front before the court. The judges sit up on a platform. There's either 4 or 5, depending on what's going on a particular day. And then the attorneys stand up one at a time and argue their various positions. And during the course of the oral argument, the various justices can ask them questions. So the object, if you're the appellate lawyer, is to try to really present to them your best case, but to shut up immediately and respond responsibly to their questions. You don't want to interrupt the court because the court obviously knows what it would like to know about. And your job basically is to respond to their questions and try to address them in a meaningful way.
I've been to the second department a few times, and what I've noticed is that they've really they really have read the papers.
That's called a hot bench.
Oh yeah, they're a hot bench. And
that's a hot bench. A hot bench is a good bench, and that means that they've had their law clerks have gone through everything, and the court has gone through everything, and they're prepared to ask the questions that they need to know to try to resolve the legal issues. And sometimes I don't know about the second department in particular, but I know some courts have an idea before the argument of what they would like to do with it. But I don't think that they actually decide it until after the arguments. And then after the arguments, the judges vote and they decide, what the outcome should be.
Now, I remember in a case that I had, we were in Supreme Court in Queens, and my opponents made a motion for summary judgment, meaning that they thought that they should automatically win on an issue of liability. The court denied their motion for summary judgment, and the other side did an interlocutory appeal.
Okay.
Right? So
that's correct.
Right? They did the appeal. And what was very interesting is there was a panel. I can't remember. I think it was an odd number, so I think it was like 5.
That's good.
And you could always see that they have the big stacks of paper
correct.
in front of them. And the first thing they said to my opponent was just one simple question. And it was like, Mr. Smith, are you seeking summary judgment for $30,000, $31,250, or $36,400? And then as soon as I saw that and heard that, I knew exactly how the case was going to go because it was obvious that they were going to deny the appeal. So what was interesting is the attorney really couldn't answer the question because if you have to pick one, then the answer is it's not ripe for summary judgment.
Right.
And then they went into some other things about invoices and accounting and whatever. And then what's interesting is they looked at me and they said, "You don't really have anything to add, do you?"
Well, and you know what? That's helpful because they're very busy and they have a lot of legal issues to address in the various cases, so they want to get right to the point.
Right, but I couldn't help myself. So what I said was, Well, I just want to make one really fast comment because, my client paid me to be here.
Well, what's interesting is a long time ago, a couple of years ago, I actually participated in a moot court and served as a moot court judge in one of the federal courthouses in Brooklyn. And that was interesting because I realized from actually, serving as a mock judge that it's very hard to remember from the first case to the last case. There were maybe 5 or 6 cases that we listened to, and then we had to rank the litigants, the young attorneys that were presenting the case. They were actually law students. And that was interesting because you realize how difficult it is for the judges because they have so much to listen to and so many briefs to read and so many arguments to hear. And you realize the difficult situation it must be to really hear so much of this every day. And that's why it's good that they really get to the point when they can and ask questions that are important to them because they can focus on the issues.
I remember I was once in Brooklyn Civil Court, or as they say, Kings County Civil Court. And I saw a case involving something like 12 people. There was like 6 on each side. And it was being translated into a different language. It was Russian. And I remember listening to the 2 different translators sort of speak on behalf of the groups. And it was really hard as someone sitting there, not as the judge, but just sitting in the audience. I was waiting for my turn. And I really, if I was in the bench, I really don't know how I could have been able to make a decision because it was very hard to determine who really should have won. A lot of times I think people think that it's actually easy to render decisions or things that are really, 100-0 or.
Well, what's interesting, what is good about appeals is that unlike being in the lower court, if you're in civil court or Supreme Court and you're a judge and you're hearing matters in the first instance, it's either a jury or a judge making decisions, making fact-finding decisions in order to decide a case, such as a trial. You have issues of credibility. You might have a battle of the experts. That's a different situation because on an appeal, you're not just hearing the arguments of the lawyers, you're actually looking at the briefs. And the briefs are tremendously helpful because when you write an appellate brief, you need to have a page citation to every single fact that you state in that brief. So that if the court wants to remember something, it can actually look at the brief, go to what's called the record on appeal, and actually look up the facts to which you're referring. So it will have the evidence directly in front of it. The other thing that it can do is it has access to your legal arguments. When you write an appellate brief, what you're doing is you're putting in your case citations. What that means is you're going onto Westlaw or Lexis or one of these legal research sites, and you're researching the various legal issues. And everything you say in the brief should have a citation to case law or statute or to the legal authority that's supporting your legal position. So it does, I think, help a lot because it's not deciding it in the first instance. It's trying to figure out, almost like a Monday morning quarterback, but not really just a critique. You're trying to figure out whether what happened below was appropriate or whether there was some sort of legal error or factual error that needs a reversal.
All right. Well, when we come back, I'm going to ask, how do we recapture the emotional atmospherics in an appeal brief? We'll be right back. This is Richard Solomon with my very special guest, Carol R. Finocchio, appellate attorney. Welcome back. Richard Solomon, taking care of business. And I'm with appellate attorney Carol R. Finocchio from New York City. And because this is a nationwide show, so they need to know where you're from. Okay, so before the break, I was kind of sharing my trial experience, which is when you're in trial, there's a 3-dimensional element to a trial. It's atmospherics, there's emotion, there's timing, there's the way you look. There's sometimes anger, sometimes sadness. There's all kinds of things going on in a trial because underlying most litigations is some psychological element, whether it's betrayal, breach of trust, breach of honor, breach of commitment, whatever it is. And then there are people who are so upset and they couldn't resolve their difference outside of court that they needed to hire intermediaries, meaning lawyers, to formulate their cases and argue them. And if you went through the collection of all the evidence, which is called the discovery phase of litigation, and then you end up in trial, there's a whole bunch of things that go on in trial. You meet with the judge beforehand to discuss the case. Sometimes there's juries. There are motions. There are motions to eliminate things called motions in limine, or to limit. There's jury instructions. There's fights over all kinds of things and what the jury will see, authenticating evidence, pre-marking evidence. Nobody sees this in an appellate record, but it's all critical to the trial. Now, when Carol sees the trial transcript, she's looking at something very two-dimensional. She's looking basically at a sheet of paper with lines on it that are numbered, and that's the transcript. And they'll say, Mr. Solomon, the court, blah, blah, blah. And she'll read that, but the transcript reads kind of neutrally. Like if I say in court, Your Honor, that's completely appealable. No court would rule that way. And if I say it sort of emphatically or whatever, it doesn't read that way. Much like we read emails more in our mind, the way we think they should be read, as opposed to the way the sender actually thought about it. So how do you capture in the appeal that psychic atmosphere and try to encapsulate that both for yourself and to retranslate that for the appellate lawyers?
Okay, well, that's a fabulous question, because part of the skill of being an appellate lawyer is really trying to recreate what happened at the trial, but you're taking a different tack. What you're trying to do is working within the confines of the evidence that's in the record. You are trying to propound a certain position, whether you should win or lose. Now, at trial, from what you're describing, there's a lot of theatrics, there's a psychological element, there's drama. But in the end, there has to be evidence. And the real skill of the trial lawyer is the ability to put in evidence to support their position, but then to use the drama and the theatrics and the psychological element to actually achieve a verdict in your favor. What will happen is, let's say you get a verdict in your favor, you've done a great job, and I'm the loser and I want to appeal. I would appeal it. And what I do, when I do an appeal, the very first thing that I do is you have to get the entire trial transcript, and you have to give it to your adversary, and you let the trial lawyers read it to make sure there's no mistakes in it. And then what I do is I digest that trial transcript page by page. It's a long, painstaking process. I want to know every word that was said in that trial, every piece of evidence that was put in to the record. I want to see the photographs that were put in. I want to see the medical records, whatever was put in there as evidence. We take copious notes on. I digest the jury charge. I want to know, what was the jury told they're supposed to find? How are they advised to apply the law to the facts? How are they, what instructions were they given? And then what happens is, once you have all of that down, and then you see, what did the trial lawyers say during the course of the trial? Sometimes the lawyer will make an objection and say, Judge, you should be charging, assumption of the risk, whatever the case may be. And if the court declines to do it, then you know that that's something that you should research and see if that's a potential issue for the appeal. Usually the appellate lawyer will speak with the trial lawyer after the trial to get some semblance of what he or she believes are the issues that have come up at the trial that may be viable for the appeal. Sometimes the appellate lawyer finds different issues, but generally there's some sort of consensus between the trial and appellate lawyer about what the issues are and should be. And then what happens is, after you've done all of that, then you can go back. Once you figure out what your issues are, you go back and you actually write up your appellate brief. In doing that, you write up your facts with page citations to where in the trial transcript the testimony was or the evidence was. And then the skill comes in to capture that drama. You want to quote what I find is helpful is you might quote, if there's a particular line of testimony that's very dramatic, you might quote it in your brief. But it's hard to explain the process of doing it, but the writing process, it's almost like writing a novel. You have to stick with what you have in terms of the evidence, but write it in such a way that it's compelling. But it's certainly not as exciting as being a trial lawyer. It's much drier, unfortunately, and it will read. You really don't want to use too much of a dramatic flair in an appellate brief. You want to really kind of stick to your facts, because here your job is to show that the evidence supports the arguments that you're making, and that that if you're the appellant, that there was some sort of error that you think was a fundamental, or I should say legal error, to get you a new trial or to change the outcome in some way.
Have you ever had an instance in which you were asked to be the appellate lawyer at the trial level and actually sit at the trial and take notes in anticipation of an appeal because it was a high-stakes case?
I have been. This is an interesting question, and I take a different position than some firms. I'm a small firm, and for me, I spend the bulk of my time actually writing the briefs, so it's very hard for me to lose the time to go to a trial for several weeks, simply because of the volume of work that we have here. But there are some firms, especially bigger firms, that do have a service where their appellate attorneys will go to court. Now, my thinking on that diverges from some attorneys. I don't really think that's the place necessarily for the appellate lawyer to be. Sometimes, like for example, insurance companies will sometimes use that as a strategic maneuver to suggest that they will be appealing in the event of an adverse decision. I don't necessarily know that that's essential. I think that if you have a really great trial lawyer, that it's not really necessary, because the appellate lawyer is there for after the fact. It's almost like being the Monday morning quarterback. Do you really need your Monday morning quarterback at the actual game? I don't know. Well, is it better to watch the rerun of the tape and pull it apart?
There's two schools of thought, because in some ways, as a trial attorney, I think I would like, in a very high stakes case, I would like the appellate lawyer there, because I would actually make an objection, and then I would actually almost say, look, I have my appellate counsel here, and I've been informed that, ... So this way you're actually embedding in the record your appeal points with the person who's the most expert at the appeals level.
That has happened. There are appellate lawyers who do go to court during the course of the trial and consult with their trial attorneys. That has happened. I have not done that intentionally. I don't necessarily. I have tremendous respect for trial lawyers. I think that trial lawyers, part of your job as a trial lawyer, in addition to doing the evidence, is you have the skill to do the theatrics and the drama. But part of the skill also, I think, for trial lawyers should be to know the law, and to do your best to really understand the things like the charges, and to understand what the various things are, because without that, that's the backbone of your appeal. Because as you pointed out previously, the theatrics don't always show up. And the theatrics without the evidence to back it up isn't going to sustain what you did below.
Right, and just for people out there, it's not theatrics in a way that you are thinking. It's just that there's
presentation.
There's pace, there's timing.
Yes.
There's the aha.
Yes.
There's the great moment is when you take a witness and you cross-examine someone. And by the way, for people out there, cross-examination is known as the engine of truth, the great engine of truth. And then what you do is you confront someone maybe with a statement that they made under oath somewhere else or something, and they're caught off guard, and you really catch them, and you reduce their credibility before the court as being less than perfect or less than credible.
And that all comes out in an appeal. When that is done, that's like really great trial lawyering, and when that's done, that can be captured on an appeal, because what happens is, you'll say so-and-so testified about the accident, and then you go on and you talk about what they said, and then you'll say, nevertheless, on cross-examination, when confronted with their statement, they were, explicitly unable to, recall what they said when confronted with their statement. They denied making it. You know what I'm saying? You can go through the testimony on cross-examination and basically write in your brief in a way that reflects the drama that happened below.
Are there times when you have read a transcript and you advise the people who are asking you to appeal not to proceed with the appeal?
Absolutely, and that is one of the most important qualities, I think, of an appellate lawyer. There's a few things that are very important to me. The first thing is, do you have merit? And if there's absolutely no merit and you believe that it really would be a frivolous appeal, you have the absolute obligation to advise your client and to tell them that they shouldn't take this appeal. And it doesn't happen often, because many times, the clients are actually pretty sharp and they know when they perceive legal errors. They're pretty experienced, especially in the insurance industry. But there are times when I get matters and I say, no, I really don't think that this is a viable appeal, and you're better off either just paying this or not taking it if it's an interlocutory appeal, because you really don't have a legitimate ground to stand on. And the clients appreciate it, because nobody wants to do something that's frivolous, and it's not productive.
Let's put it this way. This is a trickier question. Have you ever had conferences where you would assess the risk of making bad law?
Absolutely. And that's very common in the insurance industry. What happens is, people do, the law is ever changing. That's the first thing. So there are times when you take an appeal and you believe that the law is changing or should be changed, and you have a viable basis to make an argument for that. And when that happens, you have a conference call, you decide whether it's worthy of pursuing, and if the decision is made to pursue it, that's often what you do. But there are times when I've had clients say, this is not the case. We think that that's an issue that needs to be pursued, but this is not the case, and we really don't want to make bad law, because if the case gets resolved and it's against us, and the court comes down conclusively on an issue against us, then until it gets to the Court of Appeals at some point, if it gets there, we're stuck with the bad law. So yes, that does happen frequently.
What did you say is the trickiest part of being an appellate lawyer? Is it the writing? Is it the client management? Is it delivering?
I think, it's not, I think with experience, like I've been practicing now for, 30 years or more. With experience, it's a little bit of everything. I mean, the client management isn't so much the issue now, because I'm very well established. When I was younger, I guess, for the younger lawyers, you're more nervous with your clients. But now I know my clients fairly well. I think the hardest part for me over the years has been those times when it's crazy busy and you're writing as fast as you can, and everybody wants a piece of you, and you have deadlines, and, you really don't want to move to enlarge your deadlines. You really want to try to meet your deadlines as they're due and work ahead of schedule. But there are times when simply it's a very overwhelming task, because the law, as they say, is a jealous mistress, and to do appellate work, it doesn't happen quickly. It's like writing a novel. You can't just sit there and write. You have to really, you have to develop it. What you were talking about, putting a trial together, getting the evidence ready, doing your motions in limine, the pace, the timing, all of those things, well, we have that in appeals also. The first thing that I do is I pull apart the trial transcript, I digest everything, then I go back and write a very rough version of the facts. And then once I really understand what happened at my trial, Then I go and I do the legal research on the various legal issues. And we don't just research it, we research it to death. You want to find everything. You leave no stone unturned. I've been known for writing big briefs. Somebody once said I write a magnum opus every time I write something, but I can't help myself. I believe that you want to educate your adversary and the court so that they have before them every available tool they need to make a decision. And you do that by really digging into the research and educating everybody. And you want your adversary to be educated too, because then they know what their odds are on an appeal, and not often, but it does happen during the appellate process where matters will settle.
Plus, you want to create a brand, the Carol R. Finocchio brand, which is, hey, we do good work.
We do good work.
We do good work.
Right.
All right. When we come back, I want to ask the question about legal research databases, where to find law. So we'll be right back. Keep it locked here at Taking Care of Business. Welcome back. Richard Solomon with my very special guest, appellate attorney Carol Finocchio. So when we were coming back from the break, we were going to talk about resources for legal research. Could you share some thoughts on that with us?
Yes, of course. Well, the most important websites for attorneys, people use Westlaw and Lexis. They've been around since the old days, and many attorneys use them. But there's also wonderful resources for litigants that don't have the ability to subscribe to these platforms. One of them is NewYorkCourts.gov. You can search statutes, including the New York City Administrative Code, on this website. What you do is you go to NewYorkCourts.gov, you put the word statutes in the search line, you hit New York Code and statutes, you hit New York State laws, you start, scrolling around on the menus, and then you'll be able to find the index, which has all of the statutes, including topics such as the general business law, the civil practice law and rules, all of the various topics that you would want if you wanted to do your legal research online. Then what this website does also, which is very helpful, is it lists the county courthouses that have law libraries. So if you didn't want to do research online, you can actually physically go into a courthouse that has a law library, do the research in the law books, but also the website lists public access computer terminals for electronic research, such as access to Lexis, and there's something called Lois Law. Lois Law is another research platform, much like Westlaw and Lexis, but I think it's a lot less expensive. I have never personally used it, but I know of attorneys that have.
I've used it. It was part of a package of benefits that I had in a thing that I had, and you were given Lois Law as an access. It wasn't bad. It really, and considering that it was part of a group of benefits that you got, like for being part of a bar association kind of thing. Oh, okay. It was actually pretty cool.
And was it easy to research? How did you research?
It was not as robust as I recall. I don't remember it was as robust as like Westlaw, but you know what? It was good enough. It was definitely good enough.
Well, that's good. See, in appellate practice, the problem that we have is that you have to be state of the art, and you always want the latest case law, and you always want to make sure that you haven't missed anything in any case you cite. You want to call, it used to be called shepherdizing, and now Westlaw calls it key citing. So every case that we cite in a brief, we want to research and make sure it hasn't been overturned and that there isn't anything later and better and greater. So a good research platform is really critical when you do appellate work. If you're just doing general legal research and you're not really trying to be state of the art, or you don't need to be, then it's helpful to have access to these other platforms. The other thing that the NewYorkCourts.gov is very helpful for is they list links to each judicial department of the appellate division, including decisions. So that's also very helpful. The other thing that's also good is it has the New York City Administrative Code, which is very helpful if you have litigation involving buildings in New York City.
I do. Oh, yeah. 19-102 is one that always seems to come to mind.
Oh, there you go. That's so funny. Well, the other thing that's very helpful is that the NewYorkCourts.gov website has a lot of pro bono resources. You had asked about that, and I think it's very important for the public to know that there's many resources if they don't have the ability to hire an appellate lawyer. The court it has a court help section on NewYorkCourts.gov, which addresses appeals. And my favorite statement on the website says this: appeals are hard and take a lot of time, effort, and money. Read this section first in deciding whether you should take an appeal. I think that's a fabulous statement because it reflects that appeals really aren't that easy, and they do take a lot of time and money. So you want to be sure that it's necessary to appeal before you decide to go forward. With respect to appeals, the court rules provide for motions and applications for poor person relief. The civil practice law and rules in New York, as you know, it's called the CPLR. There's two sections, 1101 and 1102, that they talk about motions for permission to proceed as a poor person, and they address the privileges of a poor person. What that means is you can ask the court, you can make a motion and request that the court assign an attorney. The county or the city will pay for a transcript of the proceedings. You're requesting that the appeal proceed on typewritten briefs rather than paying the expense of a printer to reproduce the briefs. And you're asking to dispense with costs and fees unless the poor person recovers a money judgment or settlement in his or her favor. The court's website is great because it has a sample motion for an order granting permission to perfect an appeal on an original record in typewritten briefs, for a free copy of the transcript, for exemption to any fees for transferring the record, etc. Now, just because you think you might be a poor person, you aren't necessarily. If you're making a motion for poor person relief, you have to show several things. The first is you have to show the amount and sources of income that you have. You have to list your property and its value. You have to show that you're unable to pay cost, fees, expenses, etc. to prosecute or defend the appeal. You have to discuss the merits of your arguments and whether any other person is beneficially interested in any recovery. I think what that means is if you have a company funding your lawsuit, for example, you have to disclose that to the court. Or if you have someone that bought your judgment, I think you have to disclose that sort of thing also. Finally, if you make a motion for poor person relief, in addition to notifying the parties, you have to notify the county attorney and or the corporation council of the city in which you're located. And that gives the state, which is the one who would have to pay for this, it gives them the ability to take a position one way or the other as to whether poor person relief should be granted.
How is it a means test or just a threshold test?
I think, I've only come across it once or twice during the course of my litigation, and the one time that I did come across it, the court denied the relief because the person really didn't meet the criteria listed in the statute. They didn't talk about their assets and their property. They didn't disclose really their financial situation, so it was really somewhat nebulous as to whether they truly were destitute in the sense of needing the state to pay for the expenses and fees. So unless you do meet that criteria or make the requisite showing, the court will not grant the relief.
So let's switch gears for a second. Good old-fashioned libraries. There are different. You mentioned that there are different courthouses that have free libraries for the public to use.
Exactly. If you go to New York. Hold on, I have to go to the website again. NewYorkCourts.gov. There is a list of the courthouses that have physical libraries as well as computer terminals for e-research. And you can go physically to the library and actually pull out law books and do research that way if you choose to do so. Right,
and these facilities have copy machines, and I assume they have reference librarians that can kind of give you – I know they can't give you legal advice, but they can certainly tell you where a certain set of books is located. And
the truth is I do not know the answer to that question because, once Westlaw became available, most of the attorneys I know have really ceased using law libraries. A long time ago, I had an office in the Lincoln Building, which is a famous building across from Grand Central Station. And the reason I moved into that building at the time was that they had a law librarian and a law library, which was very helpful. And during that time, suddenly the Internet and Westlaw and legal research online became so prevalent that I never once went to a library again.
Wow. See the power of the power. Well, at some point, I think, is it Google? Somebody wants to actually digitize like the Library of Congress, and I know there's Google Scholar.
Google Scholar is interesting because, what a lot of attorneys I know do these days, and I occasionally do it as a supplement to my legal research with Westlaw, they Google the legal issue and see if they can find any scholarly articles about it or any cases directly discussing it. And it's very helpful when you have an esoteric issue and you're looking for like an approach to tackle the issue that is not really evident when you're turning it around in your own mind. So sometimes doing research online on Google or Google Scholar is very helpful. And then you get an idea, or you get a case, or you see a statute, you get something that guides you, and then you start researching from there.
I've done that. It's interesting because there are times when I've done the electronic databases like Westlaw, and I've done a search and it really didn't come up with anything. And then I would slide into Google and then see, and then I try to find something, and then I would use maybe either some language or there, and then plug that into Westlaw, and then use that.
Come into something.
Yeah.
What's interesting is that Westlaw and Lexis, I'm told, because I use Westlaw and I have friends that use Lexis, Westlaw has changed their, they used to have Westlaw Classic, like Coke Classic, I guess. And Westlaw Classic, I never missed a beat. But now they've made it very fancy. And it's not easy to research. And all the attorneys I know, including the ones that do appeals, everybody complains because they feel that it's almost been changed significantly. So you have to do a lot more digging and research it in many different ways to basically come up with the same results as the Westlaw Classic, which was more general. So it really is important to use all the resources that you have, and that's why Google is so wonderful, because it sort of adds the missing link if you can't seem to quite hit what you're looking for.
And, of course, there's plenty of commercial websites that have content. I know a lot of times when I look up things, people call me up all the time, hey, I got a speeding ticket, I got this, I got a DWI, or I got a whatever. And sometimes lawyers' websites actually specializing in a particular topic will have some articles and essays.
Yes, and what I find with things like that, for in those instances, it always pays to hire someone that concentrates in those areas of litigation. In New York State, as you know, we're not allowed to call ourselves specialists. So what we say is we concentrate. My firm concentrates in appellate litigation. We don't call ourselves a specialist, even though that's all we do. Just like the traffic ticket lawyers, I know someone who's wonderful who does that. And then there's attorneys that do DWIs and attorneys who do closings. And the trick in New York State is to find an attorney who concentrates in the area that you need the specialty.
Absolutely. I tend to have a lot of matters before the Environmental Control Board. And I'm a little bit different than some of the traditional approaches. I make motions in a lot of cases. I bring memos of law. I really fight them on the administrative code. I actually look at the administrative code and look at some of the rulings and actually go to court with that material.
And where do the appeals from there go? Because the appeals from the New York City civil courts go to the appellate term. Are the cases mostly in Supreme Court or civil court?
Well, what's interesting about the Environmental Control Board, they're an administrative court. So then what you would do is you would, and unfortunately the loss rate is very high in the Environmental Control Board. I have my own opinions about that because I think, as I say in some of my closing statements, if we're here for revenue, we'll get one result. If we're here for justice, we'll get another.
Oh, that's interesting.
So I actually say that, and it flips them all out. But I kind of feel that way because the conviction rate is just way too high. Just like when you go to the Department of Motor Vehicles and the conviction rate's really, really high. And it's sort of like, it's hard to believe that all these people are guilty and it's just in such high numbers. But the answer to your question is, you go to the Environmental Control Board, there's an ECB appeals unit.
Oh, that's interesting.
And then what happens is after that, you need to go do an Article 78 proceeding.
Okay. And that gets transferred to the appellate division, right?
Yeah, exactly.
That's what I thought. That's interesting.
Right.
Now, you also mentioned appellate term appeals.
Yeah, I get a lot of clients who come to me after they've had a small claims court experience. they'll say I had a small claims court experience and the judge didn't understand the case, blah, blah, blah. I want to appeal. And I always say to them, I actually don't know how to do that.
Well, okay. Now, small claims court, I'm not sure where those appeals...
I think that goes to the appellate term.
Okay, well, I know that appeals from the New York City civil courts go to the appellate term.
Right, because small claims is really a division of the civil court.
Okay, so if it's going to the appellate term in New York State, apparently the New York State Constitution lets each judicial department, as you know, there's 4, it lets them establish appellate term courts. However, only the first and second departments have done so. So the first department's appellate term court is in New York County. The second department appellate term has 2 courts, the 2nd and 11th judicial districts, which cover Brooklyn, Staten Island, and Queens. They actually sit in Brooklyn and Queens. And then the 9th and 10th judicial districts cover Westchester, Putnam, Rockland, Orange, Dutchess, and Nassau and Suffolk counties. They actually sit in Nassau and sometimes in Westchester, Suffolk, and Orange counties. The justices in those courts are designated by the chief administrator from justices of the Supreme Court. That court, the appellate term, can adjudicate questions of law and fact, including the exercise of discretion. So their jurisdiction is much like that of the appellate division. And appeals from the appellate term can go to the appellate division, but only by permission. So if you lose in the appellate term and you want further appellate review to the appellate division, you have to seek permission from the appellate term, but if refused, you can then seek it from the appellate division. So it's basically 2 bites of the apple. So that's pretty much how those courts work. I've argued many times in the appellate term. They're actually pretty interesting courts because they're pretty much very similar to being in the appellate division, but often the cases are obviously of a little bit of a lesser value. Not necessarily, but sometimes.
Wow. All right. So we only have a minute and a half to go. In terms of just sort of a great general advice for the clients out there, in about a minute, what can you say is the most important guiding principle in selecting an appellate attorney?
I would say find someone who does the kind of issues that you have. Appellate attorneys are really there for the procedure and their knowledge of doing the appeal, but it's also helpful to have someone, if you have a construction accident, it's helpful to get an attorney who does appellate litigation in the personal injury field. If you have a commercial case, it's helpful to get someone who does appellate litigation in the commercial field. If you have an environmental case, same idea. You don't necessarily need to have that, but it's helpful because you'll have someone who has more than just the appellate experience, but a broad understanding of the legal issues in the practice area.
All right. So with that was an incredibly important hour of radio. So I thank you for participating. And if do you have a website or anything out like there?
I don't. I mean, but I actually find that most of my work comes from attorneys. Attorneys will basically retain me to be appellate counsel to their firm and insurance companies. So I don't have a website for the general public, but I have been around the block. I'm a Temple Law School graduate. I was a prosecutor in Brooklyn briefly in the 80s, and then I worked at 2 civil law firms that did insurance defense. I worked for the famous firm of Bauer and Gardner, if anybody's ever heard of it. They're no longer in business, but it was a very large medical malpractice defense firm. And of course I worked for Rifkin Radler, which is well known on Long Island. And then since 1991, I've been self-employed in the appellate litigation field, and it's my thing.
All right. And you do such a great job. I can't thank you enough for participating and sharing your wisdom, your experience, and your tremendous passion for the law. So with that, I thank you. And for all of those out there, have a great and productive week, and we'll see you next week. Thanks for listening.